Alrighty, this is This We the People News. One more time at it. So I believe this is going to be the last final one. Unless we find some answers out of what happened to this guy, right? From Seattle, okay? Kurt. So, just like the previous video, I'm led to believe and do believe that due to Seattle and the county and the officers and all that are losing against him in court, they did a retaliation, made up a bunch of crap to put him in jail. Then he had the court hearing with this court. It was yesterday, from my here and now. Okay, it was yesterday when it was done. Okay, and this video right here was previous. This is what they're using for the courts, saying that it's been unjust. Okay, they're using this writ of Herbert Christie. All right, let's see what this. By the way, listen to this closely because it gives you ideas how to do these type of writs, right? Just saying, and educational purposes only. Okay, but I am led to believe that. Oh, while you listen to this writ, you'll distinguish what the other deal was, the news, how it basically rebutted their claims of being married, shot in the legs, and this, that, here, and there. So there is a form of rebuttal in this writ as well against what the news said. And this kind of made me led to believe it's one and the same. Okay, not 100%, like I said in the previous videos, right? But this is what it's adding up. This is what my investigation seems to be on this behalf. Okay.
That Tate wrote yesterday. He's going to try to appeal to the Ninth Circuit Court of Appeals for this writ of habeas corpus. And
by the way, I've knocked a lot of this out, but if you want to hear everything, it's the Legal Beagle. Okay, got a lot of great content. Check him out. Okay, go, go, go. Wait until you finish my video first. Give that thumbs up, and then go to his channel. What's the kids say? LOL.
I read this last night, and it was just so beautifully written, and tells Kurt's story so well that I wanted to share it with you guys. And so this is Tate's writ, and I'm going to run through it real quick. It's not very long, but I, Tate Prowse, next friend of Kurt Benshoff, asked this honorable court to grant this writ of habeas corpus pursuant to 28 U.S.C. 2242 and 28 U.S.C. 2254. Prisoner Kurt Benshoff, home address, last known incarcerated King County, for charges within the Seattle Municipal Court. He's being held in King County Correctional. So, satisfied all the elements of the statute. He says, I ask this honorable court to take Kurt into federal custody so that he may be permitted the resources needed to defend himself. As of now, Kurt is being denied pen and paper, nullifying his ability to write a writ himself. The Seattle court system has proven itself to be a violator of basic constitutional rights, doing so under the misapplication of administrative law. Indeed.
Yeah, and there we go. Administrative of never mind.
The Seattle Municipal Court system cannot conjure away basic due process rights in their administrative tribunals. This is from the Securities Exchange Commission versus Jarsky. In these family courts, Kurt properly argued that the court did not have statutory jurisdiction because Kurt was never married to his son's mother pursuant to the marriage as defined by RCW Chapter 2604, nor was Kurt ever in a domestic partnership under RC 2660-30, noting that
and I'm led to believe that right there was basically living together, and also with the extension of the common law marriage. Some states have it. Don't know about this one, but I'm led to believe that there was never living together. Okay, minimum, not even common law married.
At least one of the persons in a domestic partnership must be 62 years age or older. The Kangaroo Family Court ignored these valid arguments and proceeded without jurisdiction. The facts concerning Kurt's incarceration are labyrinthine. Summarizing as best possible, Kurt is a victim of the misapplication and maladministration of administrative law, which is what Chevron talks about, right? As well as the turning a blind eye by many judges. Kurt was essentially arrested for refusing to wear a face mask while shopping during the COVID-19 pandemic. This arrest of Kurt led to a bitter and contentious legal battle within the administrative courts of Seattle. In these family courts, Kurt properly argued that the court did not have statutory jurisdiction, therefore depriving this kangaroo administrative court of both subject matter jurisdiction and personal jurisdiction. As this kangaroo administrative court sees itself a hammer and every citizen that steps foot within its doors a nail. Kurt.
Now, that being said, I want to kind of give a side note on this, right? Anything in family court is contract. Okay, the 4D child support program is a contract. All right, dads, moms. Okay, if the other partner is fighting against you, quit signing these service agreements. Quit entering into contract. Don't. Oh, you need to sign this. You need to sign this. No, you don't. It's a contract. No government can force you to enter any contract whatsoever, and that's what the 4D child support agency is a 4D contract.
Was steamrolled and his valid arguments fell upon the deafest of ears. Kurt began filing lawsuits in both Washington state courts and federal courts, these lawsuits including every citizen and natural person that Kurt believed to have violated his parental and unalienable constitutional rights, including lawyers and judges. To say that feathers had been ruffled would be an understatement of the year. Kurt's actions gave rise to a comical display of judicial retaliation, culminating in trumped-up charges, restraining orders, and SWAT team home invasion. All these actions coming from Kangaroo Administrative Court that was then and is now bereft of subject matter jurisdiction and personal jurisdiction. It appears this kangaroo court and administrative law judge has set an astronomical bail of $750,000 for various trumped-up charges. The docket records for King County show the bail being absurdly high in the sum of $25,000 per case in reference to a nonviolent charge for allegedly violating 10 TROs. All TROs coming from Kangaroo Administrative Court with no jurisdiction, totaling $250,000. These bail.
Yeah, that's excessive bail. On top of, I'm still led to believe on bails. It's what your wages is at the time, right? If I make $100 a week, right? My bail shouldn't be more than $400. The whole bail shouldn't be more than $400. That's reasonable for my wages. If I make $4,000, then it should be $8,000 or somewhere in that realm. But the way these courts are getting everything, they keep you down and they kick you while you're down.
Numbers coming from a civil case over parenting rights. Kurt was arrested earlier this month after a SWAT team fired gas canisters through his windows, destroying Kurt's home. And I, as well as many friends of Kurt, have made numerous petitions to the Kangaroo Court seeking the information, and the judge signed a search warrant to no avail. There are very strange records now showing up on the Kangaroo Court website, showing that warrants were issued several days after Kurt's arrest, which could be precedent in some areas, but I guarantee they don't have all the elements they need, even if they produced them after. I believe the Kangaroo Court is doctoring and backfilling the record in an attempt to hide its outrageous lawlessness. Kurt has
Now, I do have firsthand knowledge that courts actually do that. That's in facts. That ticks me off when they do it.
Reported that he is not being permitted to access pen and paper, nullifying his ability to write his own habeas petition. Kurt is having his rights violated by the city of Seattle in nearly every way imaginable. And it appears no judge has the integrity to do a damn thing about it. Truly shameful displays of turning a blind eye to a citizen of the United States of America, a citizen with an unalienable, God-given rights that most certainly supersede the edicts of a kangaroo administrative court. Reasons for not making application of the district court and the district in which Kurt is held. The Western District of Washington would be the venue in which the habeas petition would typically be filed. This cannot be done, as the judges there seem to be just as corrupt and just as inept as the black robe right violators in the Kangaroo Administrative Court. Nor could this petition be brought into the Kangaroo Administrative Court, as they have already proven incapable of following the most basic requirement of due process, namely ensuring the court has subject matter jurisdiction and personal jurisdiction over Kurt. These circumstances render such process ineffective in protecting Kurt's rights, as his rights clearly mean nothing to those administrating injustice within the Kangaroo Administrative Court. Kurt's friend and my good friend Benjamin Blanchard recently filed a habeas petition on his own. Benjamin filed his petition in the federal court in Tacoma in an effort to find fairness. However, that court assigned Judge Jamal Whitehead to rule on Benjamin's habeas petition. And this is not even marked a habeas petition. They marked it a miscellaneous, because the court, we're unaware or unfamiliar that habeas can be filed by anyone but the petitioner, even though he has no pen and paper incarcerated in our jail. You know, it goes on. It goes on. However, the Honorable Judge, the absurdity of this decision cannot be overstated. The Honorable Judge Whitehead has already ruled against Kurt on several occasions, denying Kurt's pleas for injunctive relief from the malicious prosecution of the city of Seattle. These requests being denied, then lo and behold, Kurt had a SWAT team break out the windows of his home, administer tear gas in an effort to arrest him over exaggerated charges all stemming from a kangaroo administrative court without any jurisdiction. These actions alone, not only ruling in Kurt's favor, would not disqualify These actions alone, not ruling in Kurt's favor, would not disqualify Judge Whitehead. However, the Honorable Whitehead, in one of Kurt's most recent federal lawsuits, administratively ordered the clerk not to issue summons to Kurt's complaint. The clerk is obligated to issue complaints when you file one. Obligated to issue summons if you file a complaint. And the court has administratively blocked this. The court clerk is required to issue permanently completed summons under FRCP 4B. These lawless administrative actions by the Honorable Whitehead led to Kurt filing 42 U.S.C. Section 1983 lawsuit against Whitehead. In his
Okay, I'm going to stop right there before I lose my train of thought. Now, y'all, the separations of powers in the courts, okay? Judges is not a court, okay? And technically, the courtroom is not actually the court either, okay? It's the process of the paperwork going through. That is the court, okay? And judges and attorneys are bound to keep the court clean. Okay, so when they do this writ, what they should have done is said the Honorable Judge is made the courts have unclean hands and making the courts acting in dishonor and all that kind of stuff. Because what they're going to do is the other judges, if you go through there, right? Well, most of the time when you get rid of judges, it's because they made the court dirty. Not because the judge looked dirty, not because the judge made crimes. Okay? Basically, he committed an administrative crime against the court itself. And that's what they're in trouble for. Not because they caused harm, damage, and loss to us. It's because it made the court look bad.
capacity for the multitude of civil rights violations that White had committed against Kurt. The law goes farther than requiring an impartial judge so as to satisfy due process right to fair trial. It also requires that the judge appear to be impartial. USC Constitution Amendment 14. A fair trial and a fair tribunal is basic requirement for due process. And they all know this. Fairness, of course, requires an absence of actual bias in the trial of cases. Such a stringent rule may sometimes bar trial judges who have no actual bias, who would do their very best to weigh the scales of injustice equally between contending parties, but to perform its high function in the best way. Justice must satisfy the appearance of justice. Recusal of judge for judge's alleged personal bias was not warranted by fact that in previous case, Court of Appeals reversed judge sanction order, but instead to preserve the appearance of justice in what had become a complicated and acrimonious case. The conclusion is, I do not know whether to laugh or cry when seeing the miscarriage of justice and wanton criminality in Seattle's courts. Perhaps the people of Seattle would have been better off with the Democratic People's Republic of Chaz. What has happened and continues to happen to my friend, Kurt Benshoff, is an abomination. Perhaps judges don't want to see their kangaroo administrative law courts in which they sit aloft and above the people come to an end. Many kangaroo judges see the administrative family court that they rule over as a cash cow. Perhaps it's as simple as many judges being just as dumb as the rest of the people. Well, we the people are awakening from our decades of long slumber, and we can clearly see that administrative law, through administrative courts and procedures, are misapplying statutes and violating people's inalienable rights under the color of law.
Just repeat that, right? That just so touches on, and we are waking up. We are starting to study law, and we are starting to do these things on our own. They just don't like us to be in that just us club, right? That's not justice, it's just us club.
This is exactly what is happening to Kurt Benshoff, and this honorable court should have him transferred to federal custody so that he can properly write his own defense with pen and paper. So I thought that was an excellent description of Kurt's situation, and I mean, as complicated as his issues are, Tate was able to boil them down into a nice, concise way that everyone can understand it. So I thought I would read that this morning. Wanted to remind everyone that it is at 8:30 in the morning, the Seattle hearing. It was originally posted at 1:30. I had 1:30 for a long time yesterday. I've changed it, so it's updated on that, and I will leave the new notes and description of how to get on the Zoom call in this in the comment section just when I'm done. So you'll have that, and so you'll be able to get.
All right. And like I said, if you want to get his, the whole thing, go to the Legal Beagle. All right. He's got all kinds of wonderful videos, and it just keeps adding, right? Believe it or not, people, it's just average people learning the law, working together, and start kicking these attorneys out of our way. Okay? And this is what a Legal Beagle is. You kind of go in there and you start listening to people, how they're doing these things and how they're doing this, the procedures. You got to learn the statute. You got to learn this, that, here, and there. Am I 100% agreeing with it? No. Okay? My belief in our Constitution is still the Republic. And we need to get back to that and not this just us clubs, okay, which is called the bar member, right? And since there is no license to practice law, and it's just a bar card, that means also judges don't have a license to practice law either. It's just a just us club. Diesel Louis People News. Kicking us out. Till next time. Bye, y'all.